president of the Commercial Law League of America. Credit reports are a common tool for collection attorneys, but federal regulations can create pitfalls for those who aren't careful. We have two experts with us today to talk about some of those challenges. Joann Needleman is vice president of Maurice & Needleman PC, where she's the managing attorney of the firm's Philadelphia office. Joann has extensive litigation experience in state and federal courts, successfully defending creditors against claims brought under the Fair Debt Collection Practices Act, Fair Credit Reporting Act, and in Pennsylvania under the Fair Credit Extension Uniformity Act. And Tomio Narita, a partner with Simmons & Narita in San Francisco, specializes in consumer financial services litigation, unfair competition, and complex business disputes filed against members of the credit and collection industry. He's a trial lawyer and litigator with years of experience representing creditors, national banks, debt buyers, finance companies, mortgage companies, collection agencies, and collection law firms in cases arising under the Fair Debt Collection Practices Act and the Fair Credit Reporting Act. Thank you both for joining us.
Thank you.
Joann?
Thanks, Oliver.
Joann, let's start with you. What are retail collection attorneys' biggest pitfalls when handling accounts that are subject to credit reporting?
Well, I think that one of the things that collection attorneys, and really any third-party collector, needs to understand is that when they're speaking with a consumer and the consumer disputes what's on their credit report, they need to make sure that they communicate that and communicate that effectively to their clients. They're not the ones reporting, but if it's determined that they had knowledge of a dispute and they didn't tell their clients, they could be in some ways almost as guilty as their clients for not either doing a reasonable investigation or updating their credit report appropriately. And two areas that have become of greatest concern in the industry right now is ID theft. People call and say, you know, this is not my account, I don't know anything about it. It is so important for attorneys and, you know, third-party collectors to make sure that they advise their clients of this, because under the new regulations and the evolving Fair Credit Reporting Act, not only collection work but reporting work must stop. There must be a block that has to be put onto the account. You are allowed to ask from the consumer to complete or submit an ID theft report. And we will go over in our presentation in the upcoming conference what are some of the documentation that a consumer must present in order to submit an appropriate ID theft. I think, you know, also too, what sometimes runs hand in hand with credit report disputes are FTCPA disputes as well. So when you're getting a dispute regarding something on your credit report, collection activity has to stop also. So it's important for the debt collector, whether they be a third-party collector or an attorney, to understand that and make sure the account is marked accordingly until either the ID theft or dispute is resolved.
Well, you mentioned the fact that both you and Tomio are going to be part of a panel that will be discussing these very issues at CLLA's New York meeting. Your panel is scheduled for Friday, November 12th at 1:30, and we hope people will come out and see that. Tomio, what are some of the recent judicial and regulatory developments in the past year regarding fair credit reporting that the panel is going to be talking about?
Well, thanks, Oliver. We will talk a lot about both of those. On the regulatory front, we'll talk about the new regulations that have come out by the federal agencies that require all furnishers of credit reporting information to maintain written policies and procedures that govern the accuracy and integrity of the information that they report to the CRAs. And also, there are new regulations that bear on how a furnisher of information needs to respond in writing to all of the disputes that they receive directly from consumers. This is new, and as I said, there are regs out on it now that we'll be talking about. We're also going to go over the red flag guidelines and the requirements for all furnishers to have a written identity theft prevention program that's in place and that is updated on a periodic basis. So we'll talk about that. On the judicial front, we're going to be going over some of the big cases that have come down in the last year. One of the big ones that Joann and I were talking about recently that we'll discuss just came out a few weeks ago. The Ninth Circuit held that a district court had made a mistake when it had refused to certify a class action, a Fair Credit reporting class action. The district court had done that because of the enormity of the size of the damages that were faced by the furnisher. I think in that case it was something like $290 million worth of just statutory damages that were at stake. But the Ninth Circuit said that you don't consider that, and if it's class action, it gets certified. So there's some real serious remedies here. There's some serious exposure that furnishers and their attorneys need to be concerned about, and we're going to go over that in New York.
Speaking of some of those issues and exposure risks, Joann, do you have any suggestions for firms to help minimize some of that risk when it comes to complying with fair credit reporting?
We're going to talk about that at the presentation, and we're going to. I think that Tomio hit it made a very clear point. I don't think that we have set guidelines in order to comply. I think that we can try to provide information to minimize risk, and I think the most important thing is the idea of developing a written policy that's in writing, that you have, and that's updated. Whether it's weekly, monthly, daily, that will be another policy, but that all your employees understand what that policy is and follow it, and that you have procedures in place to make sure that people follow it. We're going to have at our presentation some hypotheticals that we may pose to the group, and we're going to ask people to contribute. This is not going to be a panel where we're just going to kind of spit out slides. We're coming into the audience and we're looking for you, so you better be on your toes and ready. You're going to earn your CLLA credits for this presentation.
Nowhere to hide then.
Nowhere to hide.
All right. Well, it sounds like a great program, and obviously a lot of important issues that folks involved in retail collections really need to be aware of. So thanks, both of you, for joining us today and for your insights. And we hope you'll join us as well at the Commercial Law League of America's New York meeting, November 11th through the 14th. See you all there.